to that very important question.
I'm going to call Gareth Hughes.
Thank you, Mr. Chair. Kia ora, ngā mihi nui kia ora. It's a bit late, Mr. Chair. Hey, so we're at the committee stage of the Crown Minerals Amendment Act Amendment Bill, the committee stage where we get the ability to drill down into the parts and clauses in detail, the ability to amend. Mr. Chair, I was thinking about writing some amendments, but actually we should just throw the whole bill out. I mean, this is an embarrassment for the Minister. It's a shoddy process. Bad content. I don't know why we're here in urgency doing it. But what I want to focus on in this call is Clause 14, this egregious clause, which I don't know if the Minister thought he could just get away with, but sneakily, under budget urgency, he's trying to extend out these egregious powers, these anti-democratic powers, these anti-human right powers, Mr. Chair. So Clause 14 relates to 101A and 101B in the original, or the now Crown Minerals Amendment Act, the so-called Anadarko Amendment that introduces 5 new criminal offences if protesters, and it's only on protesters, protest against seabed mining or drilling. And it's only seabed mining or drilling. Ridiculous situation where you could do the same offence on land, get about 1/3 to 1/4 of the same penalty, and a ridiculous scenario now where if you do something against one particular industry who's got government friends in the beehive, you face higher penalties and, in fact, what I believe, unconstitutional, unlawful laws, Mr. Chair. So this Anadarko Amendment was lawmaking at its worst, and that's what this Clause 14 is amending. This was legislation that had was introduced via a supplementary order paper. We've heard the mention in the Law Talk magazine about how experts were critical, but I've also got a letter here from the New Zealand Law Society, the Attorney General, criticising the process and suggesting, why can't we have a Bill of Rights amendment for substantive SOPs? It's a good idea, and I think we should look at that, the Standing Orders Committee. We saw no Bill of Rights, no select committee process, a terrible process. Now what the government's doing is trying to sneak in an abhorrent expansion of it. Now, let's put it in context. Protesting at sea, which is what Clause 14 is amending by amending the definition of offshore, that's all it's doing, is honourable. It's played an important role in our country's history, in our government's history, like when Kirk sent that frigate to Mururoa. And I note that Chris Hipkins and Jacinda Ardern had a background in the energy industry and some experience with petroleum. I had a bit of experience on the other side. I sailed on the Rainbow Warrior protesting at sea, and successfully, I might add, when the Labour government worked to ban deep-sea bottom trawling in international waters between New Zealand and Chile. So it paid off. We saw some success, Mr. Chair. What we're seeing here is it's all about supporting the mates. But this Clause 14 has dubious legality, and I'm hoping the member Phil Goff will take a call, because what we know is by adding this word, I believe we're making an unprecedented international move that I think, as a former foreign minister, he would have some experience, because I think if other states took a step like this, New Zealand would be critical, because what New Zealand is doing is unilaterally extending its jurisdiction over the extended continental shelf. This has been subject of huge international debates over the Spratly Islands between Japan, China, Sarawak, Taiwan, huge debates up in the Arctic, and New Zealand, little old New Zealand, under urgency is deciding what they want to do with jurisdiction. You know, no country has been able to sort out all the vexed grey areas in the International UN Convention on the Law of the Sea, but New Zealand's just racing ahead deciding it with this amendment passed under urgency, Clause 14. Now I want to look at the detail, because Clause 14 is interesting because there's only one word changed. It's the introduction of the word or. It was late last night when I picked up why this inclusion of the word or was so important, and I've spent the day on the phone with legal professors from various universities, international law experts who work in international forums to see if this was as big a deal as I suspected late last night under urgency, Mr. Chair, from the inclusion of or. Now, let's go back in history, because the Crown Minerals Amendment Act, the new definition of offshore, was defined originally as means any area within the territorial sea or exclusive economic zone that is on or above the continental shelf. I missed the inclusion of the word or, because actually what this reminded me of was how poor the drafting was with the Anadarko Amendment. I mean, it is actually logically inconsistent. If you're in the territorial sea or exclusive economic zone, of course you'll automatically be on top of the continental shelf in New Zealand. It was inconsistent. I thought they were just fixing this pretty schoolboy mistake of the Minister with his amendment. But actually what they've done is snuck in the word or in Clause 14. Now it's the territorial sea, the EEZ, or the continental shelf. What this is a massive expansion, because now the 5 new criminal provisions are extending out over an additional... Mr Chair?
Mike Saban.
I move the question be now put.
I'm going to call the Honourable Mary Ann Street.
Thank you very much, Mr Chairman. I rose to speak to part 2